Hi and good evening. Stefan Kazakis, Business Benchmark Group. Welcome to everyone who's on the webinar tonight. I guess a very important piece of the puzzle called tenants and landlords, rentals. A big part of our fixed costs is the rent that we pay as businesses, and we have an obligation. We have a legal obligation to some degree that's as tight as sometimes our mortgages and financial, loans. So very important topic tonight, and I'm so pleased to have interviewed David a couple of hours ago. He had a family commitment that he had to get to at this particular time, so we had to rearrange our recording and our sharing with David, who gives an exemplary, up-to-date piece of information for all of us to consider as it relates to our obligations as being landlords in some cases. And I know many of you are, as business owners. You make some really good money. You ultimately channel that money into property, and you are a landlord. For many of us, though, we're tenants, and that cannot be denied, and we have an obligation that's fairly legal and fairly tight. So David's sharing is exemplary. It's befitting his position of being national director of commercial leasing at Colliers International. So I look forward to the sharing in a moment. But before I go on, I'm going to share David's story. He's been in property since 1993. He's been a very well seasoned and travelled, commercial real estate agent, and has worked with all the big brands. And since 2017, he's been the State Director of Victoria for Colliers International, one of the biggest brands and agencies in Australia and the world. And he oversees 30 staff. He has 2.1 million square metres of commercial and industrial assets under management. And since January 2020, David is a national director at Colliers International. So we certainly have an authority. We certainly have a guy who's managing a team. Ultimately, an industry that's currently being the rock and the hard place called tenants and landlords. So I'm going to sit back for about 37 minutes of David's sharing, and we're going to open it up for question and answers. I asked David some really good questions throughout the presentation, and please get engaged, post your questions. We're going to be answering them at the end of our sharing and our pre-recorded presentation with David Kollias from Colliers International. And I'm going to be staying back till about 6 o'clock tonight to be in a live format. Of course, this is me live. Look, I'll do some star jumps. I'm here and I'm live, so I'm certainly committed to answering questions. This is a passion of mine. This has been a significant journey of mine since the early 90s in terms of property and property development, and property being a place where you grow money without needing to work. So as a landlord, but also as a tenant, I look forward to the sharing, and over to you, Rob. Let's go. So as mentioned, great to have David Kollias from Colliers International here today. The agenda we're going to be running through, and David's going to be sharing with us, and I'm going to be obviously asking a lot of questions as we go. The first thing we're going to be covering off is how have retail and commercial leases been affected by COVID-19? What does this actually mean for landlords and tenants? And what are some nuggets, some advice on negotiation? And we will be opening up at the end of this webinar for everyone's question and answers. Over to you, David.
Thanks, Stefan. Rob, if I could have the next screen, please. So COVID-19 is obviously very well known to all of us now. It's had a very widespread impact on the entire economy, and there are very few businesses now that haven't been impacted by it to some extent. So initially, from Colliers Property Management perspective, our initial engagement with COVID-19, we were all about preparing for instances of the disease in our buildings, and we're fortunate just to have one of our commercial buildings. It was dealt with very quickly, and then we sort of turned our attention to managing what were then essentially a lot of empty buildings, as we had tenants moving out. We were then in a situation where we had a lot of tenants having difficulty paying rent. Now, Colliers were not unique in this situation, so most of the other agencies are in a situation where we have tenants in distress, unable to pay their rent. The federal government had acknowledged, or has acknowledged, this situation, and early in April they announced a national code of conduct, a mandatory code of conduct, which would set out a set of principles for landlords and tenants covering retail, office and commercial occupancy, a set of good faith leasing principles to work around the virus and to allow landlords and tenants to negotiate. So the code applied to all tenancies with turnover under $50 million, defined as small to medium enterprises, and importantly, businesses had to be eligible for the JobKeeper program. Thanks, Rob.
And the key reference there, David, is they had to be eligible for the JobKeeper payment. That is the I guess the go-to, isn't it, as an eligibility aspect that avoids tenants and landlords being in unnecessary conversations.
Correct. That's right. Yeah. And we'll come to some specifics on that, because in Victoria, the law that's been passed now is it's quite specific around the JobKeeper program. So we'll cover that off.
Yeah, great.
If we go back to the federal code, so I'll just run through some of the principles you can see here on the screen. So the idea was that landlords and tenants were sharing a common interest to keep the lease going. So they wanted that the code is all about trying to get through, this sort of 6-month period where we hope that we would be able to resume normal trading, and that is basically acknowledging that tenants are going to have difficulty paying rent, and landlords need to assist with that, and they need to work together. So landlords would negotiate with tenants in good faith and work towards achieving mutually satisfactory outcomes. Okay, and all parties, or both parties, are to operate in an open and honest and transparent manner. So the more open and honest that a landlord and tenant can be about their respective positions, the better the outcome and the quicker the outcome will come about. The arrangements will be proportionate to the impact of the COVID-19. So that means that, and there'll be some important differences I'll highlight on the Victorian level, but at the federal code talked about a proportionate reduction in rent, reflective of the reduction in the tenant or the business's turnover. There was also a reference to assisting each other in dealing with third parties, governments, utilities, electricity companies, financiers, that sort of thing, to achieve outcomes consistent with the code. And the last point there, with each lease is different, obviously, and it's to be dealt with on a case-by-case basis. Thanks, Rob. So the code at a federal level is then given effect at a state and territory level. So each state and territory has their own set of property legislation, and in Victoria, the state legislature passed what's called the COVID-19 Omnibus Emergency Measures Bill, which essentially just gave power to the Minister for Small Business to pass a set of regulations. So there wasn't a lot in that original bill. We had to wait another week or so to see the regulations. And these were released last Friday, 1st of May, and they were quite detailed, again, reflective of what was contained within the code, but containing some quite specific differences from the federal code, and again, quite different to some of the other states. So New South Wales has released their set of regulations, and in some ways they're quite different to Victoria. And the code is to operate, or the regulations, from the 29th of March to the 29th of September 2020. Thanks, Rob. So what does this mean for landlords and tenants? Okay, so we already said that it takes effect from essentially the last couple of days of March to the end of September. And there's a set of, there's an eligibility criteria for leases. So it applies to an eligible lease. So that means the lease relates to a business that has less than $50 million of turnover. And we're talking about the JobKeeper program earlier. So a tenant must be, or a business must be eligible and also participate in JobKeeper. Now that's a very important difference for Victoria. Tenants and landlords are to cooperate and act reasonably and in good faith in all discussions. So that again mirrors the federal code. Now, as a process, the tenant needs to put a written request to the landlord confirming that their lease meets that eligibility criteria, which we spoke about a couple of minutes ago. So they need to confirm that they're a small to medium enterprise, and they also need to demonstrate that they're part of the JobKeeper program. Now, once that request is received, the landlord needs to make an offer back to the tenant within 14 days. Now, the offer of rent relief covers up to 100% of the rent payable. Now, that offer needs to take into account the reduction in the tenant's turnover, any reduction or waiver of outgoings that might have been passed on through the tenant. So, as I mentioned earlier, a lot of the buildings that we're looking after at the moment are actually empty. So a lot of the outgoing costs have actually fallen. Electricity costs, cleaning costs, they've all gone down, and they will naturally flow through to the tenant. The offer is to also take into account the tenant's ability to fulfil its obligations under the lease. And the last point here, which is really important, is considering the landlord's financial ability to offer rent relief, taking into account what relief may be available to the landlord from their lenders. Now, most banks aren't giving waiver of mortgage payments. Financiers are generally offering, if they can, deferral of repayments. However, this is a really important and I think a very fair provision in the Victorian regulations. So it's not just about the tenant, it's also about the landlord. So the package that's then offered after consideration of all those factors has to include up to 50% offered as a waiver. So this means that the rent, half of that package won't be repaid. The balance of the rent relief must be offered as a rent deferral, and that can be repaid up to 24 months or the end of the lease, whichever is the greater, typically over equal payments. Now, you can come to an agreement with a tenant if you want to shorten that period or if you want to make it longer. It's entirely up to the landlord and tenant, but that the parameters are they've got up to 2 years to repay that deferred rent. Okay, and landlords must also consider, but not mandatory, must consider waiving the recovery of outgoings through that prescribed period. Now, it's important to note that the outgoings are just a cost centre. They're not a profit centre. So the outgoings typically include cleaning costs, electricity costs, rates and taxes. So they have to be paid, and essentially just a pass through the tenant. So it's by no means mandatory that the landlord has to waive those, but where it's possible, they should consider that as part of the total package. Thanks, Rob. So what does this mean for landlords and tenants again? So it's important to know that if a tenant has followed the rent relief process, they are not deemed to be in breach for any failure to pay rent, okay? So they're afforded protection essentially by virtue of being under the code. A tenant that has to reduce hours or ceases to carry on business during that period is also not in breach of their lease. So if you've been to the city recently, you would have noticed there's a lot of shops that are closed up, businesses are operating on reduced hours. That's very normal. Any tenant who operates under this code and the regulations, they will not be in breach of their lease for operating under those provisions. Again, landlords can't pass on rent reviews during the prescribed period. Now, this excludes any turnover rent. However, my understanding of the regulations are that you can then apply rent increases after the prescribed period. But it's important to note that during that period from the end of March to the end of September, fixed rent reviews, CPI rent reviews can't be passed through. The landlord is also prohibited from re-entering premises. They also can't draw down on bank guarantees or security deposits, which they would typically do in a default situation. And there is also a prohibition on charging any additional fees, penalty interest for late rent or any other charges. Any agreement should also be documented in some way, shape or form. So it's important that once agreement is reached, which may take some time, bear in mind, that some sort of formal agreement is documented. This is also important if a landlord is seeking to take advantage of land tax relief, which is also available. As part of that application process, you do need to document that you've offered and achieved rent relief for your tenants in your building.
So just on that, David, I think the most important thing on this slide, on this sharing, is if the tenant has followed the rent relief process.
Correct. That's
Those first set of words, as it relates to everything else, is the key. Because if you just think by just making a phone call and pleading your case is all you need to do to either receive empathy or sympathy, you've got to follow the process. You've got to make sure it's in writing, and you've got to make sure that you're doing your bit as it relates to good faith.
That's right. That's right. Yeah, that's right.
If you're in a landlord's set of shoes, you've got to encourage your tenants or your agent to encourage the tenant to ensure that communication is happening. If you're not getting if you're a landlord and you're not getting communication from your tenant, get your agent to drive around there and meet them on site. Meet them wherever they need to meet them if they can, to ensure we are, advocating communication.
Correct. That's right. Exactly right. And it's important to note that if a tenant doesn't, if they fall outside of these provisions, which they may, so there are a lot of tenants or businesses that won't qualify for JobKeeper. So if they don't qualify for JobKeeper, they're not afforded the rights and protections under the regulations. It's still important that landlords and tenants, negotiate. At the end of the day, from a landlord's point of view, you don't want an empty building. It's better to have a tenant there that you can work with and get through this hopefully a short-term crisis and get through the other side. So prior to these regulations coming on board, we had a lot of, particularly our smaller private landlords, they've entered into agreements essentially prior to the regulations being published, and that's fine. We've done that and moved on. Now, if there is a situation where parties can't agree, the process is that they'll be referred to the Small Business Commissioner for mediation. Now, both either the tenant or the landlord can do that, and failing agreement there, it would go to BCAT. Now, we're hoping that isn't the case, that the parties can observe those principles of negotiating in good faith and try to see a path through.
And David, I know you may cover it in a couple of moments' time, but if there is a situation where the tenant is not communicating, or even the landlord is not responding, let's just say, and I'm sure that's going on, if the tenant is not communicating, they've gone silent. They sort of made a phone call 3-4 weeks ago. They might have put a loose request in writing prior to the code being, confirmed on the 29th of March. If there is a lack of transparency and communication, where does the tenant and or landlord go if there's just zero response?
Yeah, I guess we're coming at it from a landlord's point of view, obviously, but we've got a couple of cases where this is the case, where we've got tenants that aren't communicating or they're not providing that information. We're trying to reach out to those tenants. We're actually providing them with copies of the regulations and trying to educate them on that process. If worst case, and look, from a landlord's point of view, the code and the regulations are quite broad. They're designed to pick up the majority of businesses that will small to medium enterprises, and also obviously qualify for JobKeeper. from a landlord's point of view, you'd have to make an assumption that your tenant would likely qualify for those regulations. So if the worst case you were looking at, taking action that you would normally do under the lease to either re-enter the premises or recover lost rent, you would want to document all your efforts to try and communicate with the tenant, and assume that may end up with the Minister for Small Business as a mediation. Now, I can't pre-guess what that outcome might be, but from an agent's point of view or a landlord's point of view, your case looks favourable when you've demonstrated that you've made all reasonable attempts to contact the tenant to educate them about their rights, about what the regulations are all about. And then if you're then in a position where you had no choice but to draw down a bank guarantee, as I say, I think that would be looked upon favourably.
Thanks, David. That's great. Good.
All right, next. Thanks, Rob. Next slide. So advice on negotiation. So we're doing a lot of this at the moment. Essentially, now that the regulations have been published, it's important that the agent and the landlord act accordingly to that 14-day timeline. Now, prior to doing that, you need to establish, as I say, from the tenant's point of view, that it is an eligible lease. So it's a communication to the tenant, asking them to confirm that they meet that criteria. Once that's been established, always acting in good faith, being completely transparent. So we're asking our businesses or our tenants to provide as much detail about their financial position that they can. It then gives us an understanding as to where they are, what measures they've taken to mitigate, their losses. We get an understanding of the proportion of the rent expense as a proportion of their other expenses. And so that, that where we've had good early success is where tenants are happy to hand that over. And obviously we keep that information strictly in relation to that discussion. We're not sharing that information. It's to be held in confidence. But where that's occurring, we're able to have an insight on where the tenant's at. We can work out where they want to be, how they're going to get there, and then we can communicate that back to our landlord, and that assists in convincing the landlord or helping the landlord to come to a discussion about, or an agreement about, what that rent relief is going to be about. Okay, so again, communicating quickly and effectively, ensuring that information is kept private, not sharing it outside of the organisation. And then finally, as I alluded to earlier, having a document in place at the end of it that you can refer back to if there is a dispute. And as I said, you'll also need that if you're going to use the land tax relief which is available. The SRO requires you to demonstrate that you've provided rent relief to your tenants in order to get that 25% discount, which is available on the land tax.
Yeah, so I guess there's definitely merit in negotiation. There's definite merit in being engaged and involved. And in fairness, this is for many businesses, this is it's a fixed cost.
Yes.
So it's not one that you could sort of turn the tap on, turn it off, and she'll be right. I mean, for many businesses, this is their headquarters. This is their place of business, and therefore, to not treat this with the respect needed is, in my opinion, it's as important as how you deal with your team, particularly your A-grade team that you need to come with you on the journey to the next stage. So I guess some of the scenarios we're seeing, David, is, so our clients are communicating with their landlord. They're saying, look, we're certainly feeling the impact. It's in writing. I'm good for 50% of the rent. I know we don't have a firm negotiation on this yet. We're waiting for the code to come through so we have something to hedge against. And the basis of the code, the chassis of the code has been relevant, and not much has changed other than some fine little details as it relates to every state jurisdiction. But I guess our clients have gone on the front foot and said, okay, we're going to pay 50%. We know we're not going to ultimately expect a wavering of the balance of the 50%, but we will keep you engaged, involved, enrolled in the conversation, and we'll work it out in sometime very soon. So we encouraged our clients to get on the front foot and do that so that they kept a robust and healthy conversation going with their landlords. Now, some landlords have come back and have had a difference of opinion. As a landlord myself, I've had a mixed approach with my various tenants across the portfolio, because if my tenants have come on the front foot and they've been transparent, and I also know their case over the years of them running their businesses, although I don't coach them, I know what they're doing and how they're going about their business. So the ones that came on the front foot and have had a really good track record with me, I've given them everything they've asked for with huge confidence that they will and we will come to an agreement as to what happens to the deferred versus wavering ratio.
Yep.
And now the code's also explaining that.
Yep.
But if the landlord and or tenant are, let's say, agreeing to 50% and the rest of the 50% for some reason is not understood, even with the code, in your opinion, going to mediation should be the last step, shouldn't it?
Oh, absolutely, because the regulations are pretty clear. So if we look at a scenario where a tenant might be paying, say, $20,000 a year, and you come to an agreement on a 50% rent rebate package, of that $10,000 that's going to be paid, half of that must be offered as a waiver, and the balance is to be offered as a rent deferral. So it's pretty clear how that's to be treated, and that deferral is repayable over up to 2 years. So that's quite clear. What is different from the federal code is that the federal code talked about that proportionality of the reduction in turnover to match the reduction in rent. Now, that's not what's been put into the regulations in Victoria. The landlord and tenant can come to an agreement that might be less than that. So the tenant might be asking for a 50% reduction. That the landlord might say, well, look, I can only afford to pay, give you a 25% reduction, and you might meet somewhere in between. But in terms of how that's then to be structured, whatever that agreed percentage is at the end, let's say it ends up being 40%, half must be offered as a waiver and half must be offered as a rent deferral. So that's quite clear.
And that's a distinction. I mean, yes, you've got the, I guess you've got the alignment for many businesses with the JobKeeper payment scheme, eligibility, and as that is recorded now in the ATO portals, you've got that as a benchmark. You also have, I guess, the negotiation as we're discussing here, that could be over and beyond. Let's say if you're a 31% reduction in business, it doesn't necessarily mean your landlord won't negotiate, or you cannot negotiate as a tenant a 40% reduction. Correct. For which 20% can be, waived.
Yeah.
So,
and that, that reduction in turnover, it may be a bit of a moving beast. So, if we look at businesses, say, in April and March, they may not have felt the full impact of COVID-19, but certainly into May, June, where we're looking at certainly May, we've seen a lot of businesses shut down altogether and they're operating from home. The impact has been far more significant. And so you may see a business, going into a much sharper decline in terms of that turnover. Now, the regulations also give the tenant the ability to come back and ask for further relief. Now, if that occurs, the landlord is only obligated to give a further deferral of rent. So there's only an opportunity or a right to get one package of relief, which includes waiver. If there's a second request made for rent relief, it can only be in the form, or the landlord's only obligated to provide that as a deferral of rent.
I'm smiling because I just thought, what's the name of your dog?
Oh, that's Harry. Harry the
And is Harry a landlord or a tenant?
I think his personality, he'd be a landlord.
Isn't it interesting? I mean, I was running a session earlier today, and it was live, and it was a sharing with a crowd that we don't typically talk to. And my year 10 student son upstairs on the second level here, he must have been in trumpet class. So yeah. I can loosely hear the trumpet. I'm thinking, I hope they can't come through. But you know what? All is forgiven at this point of COVID, I think, and business. I guess the last question I have for you, unless you've got, again, some examples to give as to negotiating, you know, the etiquette of negotiation is, you know, do not bring them to your knees. Bring them to their senses, right? Yeah, bring them to their senses. You know, whether you're a tenant or a landlord, we're in this together, right? And we gotta go through this together. Do you have any more tips on that piece around negotiation and what you're seeing, perhaps in the last? I guess the code was confirmed for Victoria on the first the other day, but what are you seeing as a really good example of how it has worked in the last 2 weeks for you?
Look, I think, again, good examples are when, you know, from a tenant perspective, they're very upfront and transparent with their position. So I've seen, you know, some incredibly honest, you know, discussions and about tenants really opening up about, you know, where they're at. And it's pretty sad. There's a lot of businesses that are really, really suffering out there. And I think, you know, that's where you can really make a difference. On the other end, where you've got a tenant that says, well, we want rent relief, and we're not prepared to tell you, you know, where we're at. Now, obviously, you know, your business's financials are confidential. You don't want that being released to the competition. I understand that. However, you know, the more open and honest that a tenant can be, the great opportunity or chance that we've got to go back to the landlord and then say, look, this is where it's at. This tenant is really suffering. You know, they've lost 70% of their business. They're not able to trade. They're really, really struggling. The landlord then, as I said, you're better to have a tenant there that you can work with and get through this than have an empty building and have the prospect of waiting, you know, what might be a long, long time before you get a new tenant in. You've got, you know, make goods, all that sort of thing, leasing fees that go aside. You're far better to work with the tenant and try to get them through. And conversely, on the landlord side, where a landlord can show empathy and understand where the tenant's coming from, but also, you know, if they're prepared to sort of, you know, put their hand in their heart as well and say, well, look, I've got a mortgage myself, you know, I've got repayments to make. Let's try and find, you know, some middle ground where we can both get through this and think of other ways that we can help each other, whether that's through, you know, outgoings relief, you know, looking at those land tax measures as well. It's just about being flexible. I mean, I think the point is that there's, as I said earlier, there's so many businesses that have been impacted by this. There's very few people that have escaped the impact of COVID-19. So I think, you know, just acknowledging that we're all in this together and we will all get through it if we all work together and be open and honest with one another.
Yeah, and one thing we've also suggested to our clients is if you can approach the landlord and or the agent, the managing agent, obviously with something in writing, something you are engaged and totally transparent with, show them your plan for the next 6 months. Show them the plan.
Yep.
So it's not just something that's, oh God, I'm in a hole right now, I don't know what to do. Show them what are your 1, 2, 3, let's call it strategies or tactics. It's more so tactical right now to get you through to the other side. Be ready for the other side. You might be even needing next door's property because you are so convinced of where you're going. Now, we've got to tamper with excessive optimism, of course, but if you can demonstrate that you are on the forefront of strategy and thinking and hustling to keep yourself and your business, let alone the obligations to a landlord alive, but obligations to your business alive, I think that supports the case of being given the rent relief and or the support that's needed. Final question for you, mate. And I know you're a real estate agent at heart and it's in your blood, no two ways about it, right? And if you don't answer this correctly, I'll get Harry up, right? Hey, if I was in the market now to buy a commercial property, if I was in the market, let's say in the next 30, 60, 90 days, because there is a little bit of a conversation in the market now. Oh, now would be good because we can go and get things for whatever, right? There's two parts of that equation. Someone needs to sell if you're going to buy.
Yeah.
What's your quick 1, 2, 3 tip if you're entering the business, entering the market to buy right now a commercial property? What would your tip be on that?
Oh, look, I'll have to caveat this because I'm in property management essentially, so I'm not in our sales. I guess from my point of view, looking at again the fundamentals of a good commercial property, location is obviously important. Having a good lease in place, a long WALE, with a secure tenant, and potentially, I suppose, opportunities for multiple sources of income in there. So if you can, if the building has the potential to split a tenancy in half, if you've got, if there's the ability to put, say, an antenna on the roof for telephone and all that sort of thing, any of those additional revenue streams that you can look at. And I think importantly, getting a condition report done, because I think it's very important. It's like buying a second-hand car or a house. You want to know what you're buying. I think it's important to understand what you're buying from a commercial point of view as well, to understand, what's the property, is there are there hazardous substances there? Has there been asbestos there? How has the plant and equipment been maintained? I think some landlords or buyers perhaps sometimes underestimate, what can be involved in maintaining property. So that'd be my tips. Obviously, location, the lease is important, and the business is important, but also getting an idea of what condition that property is in as well.
David, thank you, and I so welcome your expertise and your authority on the matter. And I think it's timely. We timed this perfectly as it relates to our time in booking this. But from myself, the Business Benchmark Group community, I just want to thank you for your time, and we'll look forward to seeing you very soon. And stay safe, my friend. And again, keep on doing what you do. You're doing a great job. Thank you.
Thanks very much.
Thank you so much. Thank you.
Thank you.
Cheers. So I promised Rob I'll do a star jump so he knows he's out of the recording. There you go, Rob. That's one star jump. That was it was a very timely conversation, and it was a very precise sharing with all its afford due diligence and duty of care. Rental agreements, tenancy acts, code of conduct as it relates to the COVID-19 period now, officially from the 29th of March till the 29th of September. It is very legal, and within the legal component of the COVID-19 period is a component of it that is referred to, no different to the JobKeeper's payment scheme. And many of you who are clients of ours would know our conversation around it's the Good Faith Act. Don't try and play with the game, because they will come back to you and after you, and by then you may have already spent the money. So be very, very, very careful about the Good Faith Act as it relates to the Tenancy Act, as it relates to the JobKeeper Payment Act, as it relates to everything right now that is there to support those that need it versus perhaps those that don't. And we're all in it together. COVID-19 has an impact for every one of us in one way or another, whether it's in your personal space or your business space. This is I guess a health and economic, I'm going to just call it what it is, crisis. And we're certainly heading towards some uncharted waters as it relates to the economy. Unemployment rates are just growing. Looking at them again this morning, they're not looking good. And if the government, who is doing their best and they're doing a great job, cannot pull this back by December, we're officially into a recession, and that's not going to be good, because the market will contract and people's confidence will be contracted, and that has a whole ripple. However, questions and answers. We already have about 7 or 8 questions here, which are really, really cool. I guess let's start with Laurie. great summary, letter going to my landlord tomorrow, exactly what sort of commercial information should we share with a landlord, assuming a tear-stained handkerchief won't do it. Well, I don't mean to be laughing at you, Laurie, but you are a funny man. I guess, no, there's no issue with a tear-stained letter. I think that's, if that's what it is, that's what it is. But I think what's very important, and David shared it, it's certainly my my view as a tenant with Westfield, but also my view with my my tenants who I'm a landlord for. You know, those that are communicating and being transparent and being, you know, I want my tenants to be making money. I want them to be profitable. I want them to be supported as best as I can support them through this journey. But I'm also needing to pay at some point. Yes, I've deferred my my obligations to the bank, but the bank still expects 100% of what's been deferred. They are not turning up to me and saying, well, you know, JobKeeper, you can pay me 30% and you don't need to pay the other. I mean, it's just, so the information they will need is, they definitely need your most recent profit and loss statements, your most recent, if you can take images of your bank accounts, if you can show them your projected future orders, if you can show them, I guess, the actions that you have taken as it relates to COVID-19, stopping asset finance, reduction of headcount, payroll, payroll right sizing, I guess, non-fixed expenses being reduced, you know, things that I guess represent you have taken the actions, making sure you are committed to a plan and you've got a strategy, Laurie. You have a coach working with you, Laurie, to ensure that your business is supported and governed. So it's not just up to you being subjective, it's being objective. So no different to not getting rid of your managing agent if you were a landlord right now, because they are critical in this, I guess, situation. So the letter to the landlord, hopefully via the agent, because we just heard David Kollias, who is a national director. You know, the agent will be your best bet to negotiate a fairly, you know, balanced, objective, subjective, with the stats argument for you. So go through your agent, preferably, not straight to the landlord, is my recommendation. So we are talking about profit and losses, balance sheets, which will indicate your debtors and creditors, and to a certain degree will also expose your equity, which, you know, you're in business to make profits. So what? Don't worry about that. That's not a problem. Okay, question from Mark. Okay, so the agent and the landlord are same owners. If the agent and the landlord are same owners, and I don't know your specific situation there, that means you're dealing with a landlord that is hell-bent on saving 2.5%, which is a problem, I think, for you. That landlord is counting his pennies. Question for Mark. Can I walk away or break my lease if my landlord is being unreasonable and refusing to meet me halfway? I can't afford the rent. I think we just had a fairly concise sharing with David Kollias. I'm of the same opinion as well. I don't think you walk away. I think you do your best to bring people to their senses, bring people to their, I guess, their awareness of your situation. It's okay if you're vulnerable. I mean, you know, if your intention is to stay there and keep on doing business from that location, then you don't walk away from it. Now, obviously, having an unreasonable landlord can be definitely a sticking point right now, but you are protected as long as you do follow the code. You are protected if you keep on knocking on the door and documenting this. And again, if there's a managing agent involved, ensure that you are officially sending documentation to the agent, and not just, you know, just having a phone call and hoping something happens. That's not recorded. What is recorded is something in writing. So that's how you need to deal with that. But please do your best to negotiate. Don't walk away from anything, because right now, both tenants and landlords are in this together. And with good faith, they need to reach a conclusion. Last step is mediation. You can't walk away from anything. You still have an obligation and perhaps a personal guarantee. Question from Andrew. I own a property and I can't find a tenant because of COVID-19. What can I do? Look, that's a challenging one. I mean, you know, I've been working from my home office almost, you know, this is the end of the 7th week now. Some people have been away from their businesses for, I think, 8.5 weeks now. So this is going to be a very difficult time to find a tenant unless you are negotiating space and or a tenant to officially start paying post September. So you might be in a position where you could negotiate a tenant or attract a tenant on a 50% for the next 6 months lease, as long as they're committing to a 3-year lease. I don't know the semantics of your property there, but I'm presuming it's a commercial property because that's where my headspace is right now. So I guess, Andrew, if you can find someone and offer them 50% rent free right now for the next 6 months, as long as they're committing to a 3-year lease, I think there's tenants out there that would be jumping on that. And anyway, real business owners would jump on that. Pretenders and people that don't believe in the next 2, 3, 4 years of their journey won't be who you want to be attracting to that. Question for Joe. My current rental agreement is coming to an end in July. How do I negotiate a new rent agreement during COVID-19? I think most landlords right now would be looking at their existing. They'd be looking at their existing agreement. They'll be looking at their existing, levers for how increases in rent occur. Obviously, this is a new option that you're referring to. You're going to be taking, so there will be some pre-existing, ways of doing that in your rental agreement, depending on how you have, behaved as a tenant, what your track record is with paying rent on time and obliging to everything else that may have occurred in your journey till now will be where your negotiation is. So how do I negotiate a new rent agreement during COVID-19? Typically, you wouldn't be negotiating a new one. You'd be negotiating an option which already has been preset, and therefore there's 1 or 2 levers there, one of them being the agreed increase, which would have been set in the first term or second term, wherever you are right now in your option. So there'll be pre-existing caveats to where your negotiation ability is. And then there's hey, look, we've been impacted. We're going to have to recover over the next year or 2. How is it that we can negotiate this current situation? Now, I will say this. If you have been a great tenant and you have had an exceptional, almost invincible relationship with your landlord, in other words, you have paid on time, never complained about anything, did everything you needed to do, of course, all within reason, then you will have an ear that will be listening to you. But if you've been a shaky business owner, you've been a little late more often than you should, I don't know if there's too much to negotiate there, right? Maybe the landlord's hoping you don't re-sign. I don't know. Question from Lisa. My commercial properties, Rob, can you scroll up, please? My commercial properties that I have leased are part of my income and I cannot afford to reduce the rents. What do you advise? Okay, so you're a landlord. Okay, so there are plenty of landlords, and this is the dilemma. And this is why David pointed out in that presentation, he pointed out why the Victorian set of code is at this point regarded as the most balanced in the country, because it actually stipulates that it is important for the tenant, Lisa, the tenant, to be also conscious and sensitive, be empathetic to the landlord's commitments and or needs. In your case, and I'm just going to make a presumption here. I'm going to make an assumption. It may not be right, but I'll make an assumption based on what you've shared here. I'll make an assumption that you've used perhaps some of your superannuation monies to be pumped into this commercial property, and therefore you are living in fairness off the proceeds of the rental. That's your way of living. That's your income. So I guess if you look at this over the life of the agreement, and we're strictly speaking between the 29th of March and the 29th of September, I think it's important that you participate. It's legal if the tenant requests in writing and provides the evidence that certainly covers their request, or they're eligible through the JobKeeper payment scheme reference, I guess it is important to participate in that conversation and reach out to your bankers if you haven't already done that, and put a deferral for the next 6 months as to your loan repayments. Now, please understand, a deferral means that your interest will not be capitalized. It will be expensed, which means on the 7th month, give or take, you will need to be paying the interest back. Once you know what that is, you go back to the tenant and you negotiate something that's positive from that number, which gives you not only your obligations to the bank or your mortgage in this commercial property, its ability to be break even, and whatever you need as a living expense is also covered as well. So they're my tips at that. That was the last question. How cool is that? 5:59. I love that. So guys, I guess not only for your landlord, not only for your tenants, but for everything in business, how you do anything is how you do everything. You know, communication, transparency, relationships, trust, authenticity. Don't be committed to dropping people because, you know, a cloud came over your hair. Don't be committed to doing things, you know, in a way that you wouldn't want them done onto you. Build a reputation, build a track record. Start it today if you've got a gap that needs filling as it relates to communication. More communication, not less. Be honest, be transparent, be vulnerable. The handkerchief with a few tears on it will work, but you also need to demonstrate the numbers and the strategic plan so that your landlord knows that they've got a jockey on a horse that they're willing to back and go on a journey with together. I'm Stefan Kazakis, Business Benchmark Group. Power to you and your family tonight. Thank you.